Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Well, I appreciate you being on to the program, and let's get right to it. And first thing we're going to talk about is a case in South Dakota, and it really comes down to, it's a beef labeling lawsuit, but this has been a long-standing issue of, well, simply, what does product of USA label mean?
Yeah, this is originated by a couple of ranchers in South Dakota, and it's presently before the U.S. Court of Appeals for the Eighth Circuit. But this really goes to a broader issue in general of food labeling. Now, as you said, it's kind of a pivotal case on labeling of beef, so it's crucial for the U.S. Beef industry. And it's currently on appeal, as I said, with the Eighth Circuit. Basically, Greg, at its core, the lawsuit is challenging that product of USA label. And the allegation is that using that label on foreign-sourced beef has misled consumers and caused significant financial harms to domestic producers. And the reason I say that is, I bet if you were to go out around just in Topeka, Greg, and do man-on-the-street interviews and maybe stand out in front of a grocery store and show shoppers the label and ask them, do you think that means that the beef that you're buying has originated in the U.S. and all of the processing is done in the U.S., that was a cow that was raised in the U.S. all the way through processing? They probably overwhelmingly say yes. And the point of the ranchers is that label is being slapped on foreign beef. It doesn't have to be from the U.S., and that's their core argument for them, is that has caused not only a lot of economic damage to them, it's increased prices for foreign beef while simultaneously decreasing prices for domestic beef products. But they're saying this is a violation of state consumer protection laws and perhaps antitrust at the state level and state antitrust laws. And now we've got 11 state attorney generals that have filed a friendly report beef on the side of the ranchers. And and we're going to have a new regulation that starts in January that's going to change what that label says and what it means. So this is, I think that distinguishes it from a previous case that the ranchers lost on this issue. So this is a really big deal.
Yeah, because the new rule, as you mentioned, that's becoming effective next year, well, it tightens, or it strictly defines, maybe is the better way to put it, product of USA that required that the beef comes from animals born, raised, slaughtered, and processed in the United States. Now, the new rule, and correct me if I'm wrong on this, Roger, it does not directly is not directly applicable to the current case that's in appeal right now?
No, it's not. This case was filed before that rule was promulgated and developed, so it's not directly applicable to the case. However, it is something that the ranchers are arguing in their brief that says, look, we're arguing that this label is misleading, and now the government has come back in and has retooled the label to require that beef carrying that label comes from animals born, raised, slaughtered, and processed in the U.S., and so they're saying that supports our point that why did the government change the rule if it was fine to begin with? And in addition, we've got 11 state attorney generals, including the attorney general in the state of Kansas, that are agreeing with us that this has been a misleading, deceptive trade practice. And the previous court case that went through the 10th Circuit on this that had determined that the label that was consistent with the FMIA, the federal law governing labels on this, this is distinguishable from that case, because we're arguing not that we've got a label that complies with federal law, and so we're trying to challenge that. And of course, the 10th Circuit said, well, we've got sovereignty here. And you can't put the business as the packers between a rock and a hard place saying, okay, we're complying with what federal law is, therefore you can sue us. So what they're saying here is, well, this is a misleading label to begin with. And the Federal Meat Inspection Act, FMIA, this is a wrong. This doesn't even comply with that federal law, and that previous lawsuit didn't talk about that. So that's how they're distinguishing this, and they're changing the argument here in this case to more of a consumer protection argument.
Because really, for what the ranchers are claiming, and they're looking at the damages in the millions of dollars that will really date back 10 years at least.
Oh yeah. They're what they're claiming here is that they've been paid an average of 40% less for their cattle since 2015. And they say that's a direct result of what they are claiming here is unfair competition from mislabeled foreign beef. In other words, their argument is consumers would buy less of this if they knew that a beef product containing that label didn't actually mean that it was coming from the U.S. necessarily. And so, and there have been some studies that show that. Now there were some studies on the other side that support the packers' position on this too. So this case was on a motion to dismiss back in January that the trial court in South Dakota denied the packers. That's why it's at the Eighth Circuit. So we're still on this issue of whether the case should have been dismissed or not. If the Eighth Circuit upholds the trial court and lets the case go forward, then we start to get into the economic issues. So this is a big deal for the beef industry to watch where this case goes. And again, the fact that we've got 11 state attorney generals, primarily from the major beef producing states, that are on the side of the ranchers is not something that the Eighth Circuit's going to take lightly.
So much of this, it's going to affect the future in the aspect of what we see in this new rule is more termed as a voluntary approach versus what we saw previous in the past of the mandatory country of origin labeling that we saw in the past, but that was repealed earlier too.
Well, right. We had a mandatory rule that was upheld on constitutional grounds. However, the problem with that is it ran up against free trade rules, and it was deemed to be a violation of certain free international trade rules. So this is coming back as a voluntary label, which then gets us into the issue of deceptive trade practices and potentially economic damages. So it's been retooled because of those trade rules to make it voluntary, so you're not running afoul of it. That's another distinguishing characteristic of this case.
Yet interesting in that the mandatory country of origin labeling supporters, such as Senator Thune from South Dakota and Senator Grassley from Iowa, it sounds like that at least for the upcoming skinny farm bill negotiations, that may be brought up again, or at least tried to put back in to the farm bill too.
Well, indeed it could, and that's one of the things they are talking about doing later this fall. Of course, they're coming back into session here tomorrow, and we'll see if that's on the table or not. But indeed, that is one of the things they're talking about doing in addition to the bulk of the farm bill provisions that were in the One Big Beautiful Bill Act.
So for this decision, trying to figure out when a court decision will be is a hard task. But do you think something will be decided on the appeal before the year is over?
Yeah, it's possible. The most recent briefs in this case were filed about 3 weeks ago in the Eighth Circuit, and to me it looks like the briefing is probably done, and it may be in the court's hands now to evaluate the briefs and see if they want to ask the parties to file any supplemental briefs. But they've gone quite a ways down the road in this in terms of briefing the case.
All right. Any final thing on this, or that people or that farmers and ranchers should be aware of as this case continues on because of the magnitude of this case?
Well, the magnitude is high, and this is a very complex and high-stakes legal battle that has far-reaching implications, not just for beef, but for the food industry as a whole. And you've got some nuanced legal questions here, and perhaps federal preemption, but not so much in this case because it's focused on consumer protection. And we'll see. We'll see what happens here. There is an angle here for the Eighth Circuit to distinguish it from the Tenth Circuit that was decided against the ranchers. We'll see if the Eighth Circuit takes that path.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, other case that we want to talk about comes from the Third Circuit Court of Appeals, and this was a case involving a New Jersey farming operation where the court held that the Department of Labor unconstitutionally used its internal administrative process to assess over $500,000 in penalties and back wages against the farm.
Yeah, this is a very important case, Greg. And it's an important case because normally when a farmer gets into a dispute with an administrative agency, such as USDA, NRCS, some other federal agency, could be EPA, Corps of Engineers on some type of water issue or permit issue, you've got to go through the administrative process and exhaust that entire process before you can ever get to a court of law. The problem with that, and there's good data to back this up, is that overwhelmingly you're going to lose because the agency that assessed the penalty, assessed the violation, is claiming that you did something wrong in accordance with their program rules. They're the ones that are hearing an appeal and making a determination on the outcome of that appeal. So they're the judge, jury, and executioner, so to speak. Well, what we had in this New Jersey case is a farming operation that hired 19 H-2A workers. And the Department of Labor came in and alleged that they had breached their employment agreement with the workers by failing to provide adequate housing and meals and transportation, and by failing to provide a guaranteed number of work hours, which is all required under federal law. You've got to do those things. And so the allegation was they fell short in those instances. Now, instead of bringing the case to federal district court, the Department of Labor did what many federal administrative agencies do. They're going to pursue the matter through their own administrative process. And so this went to an administrative law judge, and that's where you came up with the $500,000 in civil penalties and back wages that were assessed against the farm. Well, the farm, very cleverly here, good lawyering here, challenged constitutionally the Department of Labor's authority to do that. They argued that, look, this is a violation of the Seventh Amendment due process rights. We are entitled to have our case heard by a jury in an independent Article 3 of the Constitution court established under Article 3. We should be able to go directly to court. And that is the way that the Third Circuit determined that the outcome of this case should be. They were correct. And so this is a real strong affirmation of the importance of Article 3 of the Constitution, which Article 3 is what establishes the judicial branch and guarantees a right to a trial before an independent judge, and in many cases a jury. Now, you've got to distinguish a couple of things that are going on in this case, Greg, and that is that the court is finding that we've got a case or controversy here, and that we've got to work around an exception for what's known as public rights. And if we've got a dispute, for example, over a public land system or a dispute between the government and business over federal tax, that's a little bit different. Those cases are going to get adjudicated, for example, by the IRS or by the Bureau of Land Management, and that won't violate Article 3. But here, when you've got basically potential contract violations and the imposition of a civil fine, then the court is saying that public rights exception does not apply and you can go directly to court. I think this case has massive implications on the administrative process, particularly for farmers and ranchers that have disputes with the Farm Service Agency or with NRCS when they're saying, well, you violated a contract provision of this conservation program that you contract that you signed or you signed a document to participate in this particular farm program, and we're not going to provide the compensation that we were promising in accordance with the contract because we think you violated the rules. What the court is saying here is you're not going to be stuck with an administrative appeal in that instance. You can go to the federal district court. And that is a big win for farmers in this case in general, because you're going to have a better chance with a jury of your peers than if you're just dealing with the agency inside its appeal process itself.
Which, in the end, somewhat, or probably more than somewhat, gives a strong case as far as farmers are concerned, obviously depending on how this decision goes. Yeah.
This is the Third Circuit Court of Appeals. So the only next step, if the Department of Labor wants to appeal this, is to the U.S. Supreme Court. So we're pretty high up in the legal food chain, so to speak. That's why this case is really important. And I think it's pretty rock solid. I've read it. I've read the briefs on this. And the court's opinion is pretty solid. It goes through the exceptions, that public rights exception, and said, no, not in this instance. That doesn't apply. It doesn't mean that is not still there. It is. But when you're dealing with a contract issue and violation of that private contract between the parties and civil penalties for violation of that contract, or we're just not going to pay the funds under this particular farm program, what they're saying here is you can go to court. And that is going to give farmers a greater chance to prevail. You're going to have a higher percentage that you're going to prevail in court than you would if you went through the administrative process and then the court is just reviewing what happened during the administrative process to see if there was the agency violated some rule in processing your claim. So it's a game changer, and this is a big deal. I'll be in putting this in all of my ag law seminars. It's in my Substack. I cover it there, plus the beef case we talked about is the lead article in the most recent Substack Rural Practice Digest, monthly digest article. But anyway, both these cases today are really huge. One on the merits that we've got a decision on, one we're waiting.
All right, sounds good. Roger, we're out of time, but as always, appreciate it, and they can... like you mentioned, you find that in your Substack. They can also read your blog as well?
That's correct, yes.
All right, sounds good. Roger, as always, appreciate it. Thanks, and we'll talk to you here in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.